Article 6 provides for the provision of security and an adjournment in the event that the arbitration award is on the receiving end of an application for setting aside. So I'm going to do it again. We should stop actually anyway. So, Article 6 covers the situation where the party seeking to resist enforcement has already applied to set aside the award. In that situation, the court can adjourn proceedings, and it can do so while ordering security. In the SPP and Egypt case, or at least its version in England, the issue came up as to whether or not the English court could order security against a sovereign state. Now that's really a sovereign immunity question. You can argue that it doesn't belong on this subject. But it would be very helpful if in a rewrite of the New York Convention somebody had a look at this question, because there are plenty of states whose solvency is less than perfect and where it is genuinely difficult to enforce awards. And it would be helpful if it was agreed that you could get security for the enforcement of an award where a party has applied to set it aside who happens to be a sovereign state. That leaves us with Article 7, about which we have already spoken quite a lot. Article 7.1 has two features. First, the right of countries to provide more favourably for the enforcement of arbitration awards. And if you read Article 2 correctly, it must extend to arbitration agreements, not just awards. Article 7 also mentions bilateral agreements, of which there were quite a lot at the time when the New York Convention was put together in 1958, but where there are far fewer now. Having said that, if you find yourself dealing with a country which is not a party to the New York Convention, you'd be very well advised to check to see whether or not one can find a country with which they have a bilateral agreement and put the arbitration in that country. That, though, pretty much concludes the New York Convention. The remaining provisions are mainly formalities. One would like to have some provision for the enforcement of the Convention, perhaps by everybody submitting to the jurisdiction of the International Court of Justice. That would be a good thing. It hasn't really proved necessary. Enforcement standards around the world do vary quite a lot. You would expect that. It's a convention that has been adopted by countries as varied as England and Saudi Arabia. Occasionally, pretty much every country has broken the convention at some point or another. If you think the English have been totally virtuous, you'd be slightly wrong. For many years, that is to say, until the mid-1980s, the English courts believed that if there was no arguable defence to a claim, Article 2 did not require the enforcement of the arbitration agreement. So in effect, if you thought there was no arguable defence, even though there was an arbitration clause in your contract, you went straight to court, sought summary judgment, and the court would give it to you if it agreed with you. That was a breach of Article 2 of the New York Convention. The USA had a bit of a whoops with a case called McCreary, which concluded that the obligation to refer the parties to arbitration under Article 2.3 was inconsistent with the notion that the parties could apply to court for provisional measures, which in effect an arbitrator could grant, but wouldn't be nearly as effective as a courtroom. US cases have spent a great deal of time distinguishing McCreary to the point that it doesn't really exist anymore. But the result is that every international instrument in this area, notably the model law, has to make it quite clear that the referral to arbitration does not exclude the right to go to court to seek help with the arbitration. Thank you very much.